SJC-13300, Smiley First LLC v. Massachusetts Department of Transportation.
Okay, Attorney Feldman, whenever you're ready.
Thank you. Good morning. May it please the court. My name is Paul Feldman. I represent the appellant Smiley First LLC. With me is my colleague Sean McCormick, who's on the brief. This case arises from what the government called a confirmatory taking on January 12th of 2018, in which the Commonwealth took rights in appellant Smiley First property without compensation in order to build some new tracks and a building in connection with the new Red Line subway cars that Mass DOT had acquired to test them. The government takes the position that it didn't have to pay compensation because there were really no new rights taken, because these rights were already acquired by the Commonwealth in a taking in October of 1991.
So let's just, if the purpose of the taking in 1991 is not what they say, but the purpose was to create a haul road and to relocate Conrail, do you lose anyway because the subway trains being tested is a public use in kind?
Yeah, absolutely not. Our case is not based on the fact that, and this is where the trial court, we think, made error. Our case is not based on the fact that somehow we're trying to say that the act of testing Red Line tracks isn't a railroad type use. Where the court went wrong below is that there were no easement rights available in the physical portion of the property where this new track and this building has been built. The rights under the 1991 easement had already been extinguished for further physical improvements on the fee owner's property.
How did that happen?
It happened because that's how the language of the October 1991 taking speaks. It says, number one, we are, as Justice Lowery just said, the purpose is we're building a haul road. Conrail's in the way, so we're taking some of their property, and to mitigate the damages we owe Conrail, we're going to let Conrail relocate their facilities onto our client's predecessor's property. But it went on to say, here's the property, here's the portion of our property you can establish your easements in. Define the parcel. It didn't define the particular easements that Conrail is going to establish. That gets defined by the act of relocation.
Is that the practical location?
Well, it's a combination of practical location, but also, which has been in our jurisprudence for 200 years, but it's also the structure and the language of the taking order itself.
Tell me this, if you could. How do the air rights 12 years above 20 help your argument that you just made?
Understand the question. It's absolutely critical to understanding what the taking in October of 1991 is all about. Conrail doesn't know exactly where it's going to relocate its facilities. It says, the government says to Conrail, you can relocate on this parcel, what is now 12,000 square feet. There's an opportunity to relocate. That's the purpose. That is a finite process. In 12 years, once during that 12-year period, Conrail can physically do what they need to do on my client's property, including all of the air rights. The fee owner's rights for 12 years are suspended. But after 12 years, all of the air rights that the fee owner enjoys is available to the fee owner. So, and except for those air rights that are now continue to be the subject of the easement, which is the 20 feet above where they located the rails. There has to be a moment in time where we know where we could define our residual rights. We now then know what we could do with our property. Those residual rights, those air rights, are incredibly valuable.
Because it encompasses the entire parcel other than the 20 feet above.
But that is the incorrect reading of how the rail rights work. That would actually expand or look at the 1991 order in an expansive way. When this court instructs under General Hospital, you do the exact opposite. For 12 years, the Commonwealth got to use the air rights, all the air rights. After 12 years, every bit of those air rights are now my clients. They're the fee owners. And I'm not just talking about the air rights from 20 feet up. I'm talking about the air rights from the ground up where we don't have tracks. Where we have tracks, yes, the easement
But I meant
continues
that
to...
portion other than that is taken up by the Conrail line.
Other than what was taken up by the Conrail, we enjoy all of those air rights that don't start. There's not a magical line hanging over this property at 20 feet. It's the reverse. Conrail, or in this case now Mass DOT, they have that rail line, they have those rights above that rail line in perpetuity. They wanted to use that line to test their red line tracks, no problem. We are not objecting to that, and that's what the trial court missed. That's what the Commonwealth misses. That's why Leroy has nothing to do with this case, yet it was so heavily relied upon, and in the trial court's opinion, determinative. It really isn't even relevant. The importance of the air rights is we have those valuable rights which we would be deprived of using. They would become completely illusory if Conrail or now Mass DOT could keep on coming back to this same parcel. Oh, we want to add another line, and we want to now add another line, and we now want to add a third line, and keep on carving out air rights. How do I use my air rights subsequently? That's what the 12 years is all about. And one other point, because we're looking at an easement to build the whole road, let's construe it in its entirety. That 12-year period is not just associated with our air rights. That 12-year period is the same period that this same taking order uses when it takes temporary construction easements to build the whole road. So what the Commonwealth was saying is, we need to build this whole road. Conrail, you need to relocate your facilities. We're going to be taking temporary construction easements to build our whole road. They're going to last for 12 years. You're going to have the full use of air rights, which is an example of like a temporary construction easement in the context of trying to hoist rails, if you think about it, saying, and you're also going to have 12 years. You're going to have the same 12 years that we have to build the whole road, you have to relocate your facilities. And when that is done, your easements, the easements that you now will enjoy in perpetuity, they're defined, we know where they are, and we know the vertical limit. And those are the easements, not this notion that you still magically have rights over the balance of the fee owner's property. If, in fact, that's what this taking order says, that's the taking of a fee. And we know they didn't take a fee. They specifically said they were taking an easement.
Let's go back to the first issue that we have to address, which is the purpose of the 1991 taking, and in the context of an eminent domain taking. Why aren't the appellees right that the purpose is that it's for any railroad purpose, for Conrail, for any railroad purpose?
Two answers. First answer is that's not what the taking says. The words couldn't be clearer, and it's not only said once, it's said multiple times. Right in the beginning of the taking order, it says, for the convenience and necessity of the Commonwealth, we're going to lay out and take charge of a road, and that certain railroad facilities be relocated. That's how it starts. That's what this taking is about. We're laying out a road, and you have to relocate some railroad facilities. Then you go 24 pages later, and it specifically says, In connection with the laying out of the state highway, which we just explained to you, it is necessary to relocate portions of railroad rights-of-way, and land is hereby acquired for said relocation. The purpose is so, Conrail, you could move some of your assets onto this property that you deem you need to move. We know you haven't figured that out yet in 1991, so here's the parcel in which you can move your assets. When you move your assets, boom, your rights will be, that undefined easement rights will now be located and defined as contemplated by the language of the order, which says we now know the vertical limit. And, by the way, when you move those assets, you can only use those assets for railroad purposes.
What's the impact of the fact that this is but a fraction of the numerous parcels that were taken to build the Hall Road? How does that play into the analysis of the scope of the easement?
I think the impact of that is this taking order is meticulously prepared. It is thoughtfully prepared for the purpose for which the taking was made. And that was the government in 1991, as part of the Big Dig project, needed this Hall Road. And that's what the purpose of this taking was for. And yes, it had an obligation to, and wanted to mitigate the damages it was causing Conrail, because it was taking property from Conrail by fee, but only then giving them easement rights. It wasn't putting Conrail in an equal position.
Why not? It was basically saying, okay, we're taking this from Conrail. Conrail operates a railway there. You get to move your railway operations over here.
And the difference is, why is it not equal, is because if they had given Conrail the fee, Conrail can move its operations there. It could then change where the tracks that they originally moved would be moved. It could add tracks. It could do whatever they want. They own the property.
They could do whatever they want for railway facilities. They didn't have to recreate the exact. Conrail owned that property before. They could do whatever they wanted on that property before, right?
The
You're
property
trying
that
to
was
put
taken
them-
of Conrail's.
Yes.
Yes.
You're trying to put them in as equal a position as possible. You don't want them to put a hazardous waste site there. You don't want them to do certain other things, but they can create a railway and move their railway operations.
So, yes, I would say two things.
And buildings too, right?
I would say two things. I would say that I know that you feel like they were trying to put Conrail in as equal position as possible. If that's what they were really trying to do, they knew how to do that. Just take a fee in my client's property. Don't take the easement.
Well, having dealt with they wanted to save themselves as much money as possible, too.
Correct. And by saving
That's what was really driving this. They couldn't care less about Conrail. They didn't want to cost the Commonwealth more money than is necessary.
Exactly. And at the same time, they didn't want to have to pay Conrail more money, which is why they mitigated the damages by coming to my client's property. They wanted my clients to be left with some real rights to use its property afterwards, because they didn't want to pay my client more money.
Right, that's exactly.
And so they carefully.
But they paid your client some money, and they paid Conrail some money, and we're sort of balancing all of these things.
Right, but they paid Conrail less money for taking their fee than they would have, because they then gave Conrail an easement, and they paid my client less money than would have than taking a fee.
Right.
Well, there's a consequence when the government is figuring out exactly
Right, but we're trying to figure out what they left for your client. And I think Justice Lowey's question about air rights is probably the strongest part of what you have, because I don't read the any railway the way you do. I read it as they can move railway operations over there.
And we agree with that. They could move any railway operation, and I'll go one further. I will agree with the court that for the first 12 years, they could have put on multiple tracks in that time period. They were free to use that property to relocate their facilities however they chose, wherever they wanted to. And they could have occupied much more, but once they finished their relocation, which needed to be done in 12 years, the definition and limits of the easement had become established. And that's their perpetual easement rights that they enjoy in perpetuity. Now, the MBTA...
And I'm sorry, and you're getting that because of the air rights limitation? Because it, you know, the
Well,
words that
there's-
you read before, that the easement is to relocate and relocation, none of that says within the first 12 years.
That is all happening. That's all happening within 12 years.
Where does it say that, 12
Say
years?
that.
Other than the air rights section?
Well, because if you don't complete that process within 12 years, the residual rights of the fee owner arise, and you're not going to be able to physically come on with a crane or hoist.
you don't
You're not
have
gonna
No,
be able
but
to physically
looking at
do
the
it.
language of the taking, where is the 12 years other than in the air rights?
It's only in the air rights, and
That's why that's the critical part of your argument, because,
Absolutely, it informs the court as to the structure of this taking. And another important thing to realize is that now Mass DOT comes back 27 years later and says, well, we have another project, and it's a railroad project. But that new project is now, we want to do that new project on land that is, they don't have an easement in, because the easement was established by the relocation.
Can I ask one other, so in the 20 feet above, does that stay with forever? I can't remember. There's part of.
Yes.
See,
No,
see, I take it your sister's gonna stand up and argue, they were given the right to move their railroad and facilities, and above those facilities for 20 feet, they can move it around wherever they want. I assume that's what she's gonna say.
Well, if that's what she's going to say, we know then she's reading the words, first of all, not literally the way they're written on the page, and she's reading the words against the way this court instructs us to read them, as we learned from General
Well,
Hospital.
the problem we've got is the General Hospital and a subsequent decision are sort of inconsistent with each other. That's why one of the reasons we took the case is we seem to be having two different lines of analysis out there, right? Do you want to address that before you sit down?
Thank you very much. I would really like to address that, because if you heard the debates we've been having in my office for the last 2 weeks, we've been talking about, did General Hospital overrule the appeals court in Mugar? Is General Hospital inconsistent with Mugar? How do we?
Oh, and also, there's the later decision by Justice Lankman, a footnote that cites Mugar for the point that is inconsistent with General Hospital, right?
Which is also the 2016 case. Yes, Your Honor. And we've been, and I said to myself, well, I could do two things in front of the court today. I could either say, look, General Hospital did overrule Mugar, but now that's in doubt because of the footnote. Or I could say, no, there is a way to reconcile these decisions so that they make sense.
That would be very helpful.
All right, so here's the way
yeah,
I
let's
would.
go with path 2.
All right, so I'm going to go path 2. I'm going to try to help the court reconcile. You have to read Mugar in the following two ways. Number one, Mugar was not interpreting the scope of an easement. It's not what that case is about. That case is about how much taking damages the T had to pay. And the T argued, well, we shouldn't have to pay so much taking damages because we're not going to use everything that we took. We know now we're not going to use everything that we took. And, you know, there's this practical location doctrine that if I only practically use less than my rights, and that could establish the limits of my use, don't charge me for the fact that I'm using less. And what Mugar said was, wait a minute, it doesn't work that way. You are the sovereign. You wrote your taking order. You could have wrote it any way you wanted. You got to live with what you wrote, because your rights vested on the moment that taking order hit the registry of deeds. At that moment is when you owe your taking damages. And at that moment, there was no constraints about what you could have done with the property that you took in Mugar. You pay for the entire property, even though you're only going to use one strip for access. If that's what you wanted to pay for, that's what you should have taken. And that's the context of Mugar. It's actually the MBTA arguing practical location should be available to me so I don't have to pay damages. Now, the MBTA is trying to say, well, because Mugar says practical location is not available, We should toss the doctrine that's been in our jurisprudence for 200 years that helps people establish easement rights. Why? Because, this is an eminent domain case and it doesn't apply. That logic is the opposite. It's completely perverse, and I'll explain that as my last point. If this was a voluntary easement between two consenting parties, practical location doctrine would be available to define what those parties did when they didn't define it in the language of their agreement with certain meets and bounds. Here we are in an eminent domain taking case where we are talking about the power of the sovereign to take someone's private property. It was what our founders wanted to guard against when it said, we'll let you wield that extraordinary power, but we're going to put a check on it. You got to pay. You got to pay just compensation if you're going to wield that power. And the courts go on to say, and since you could do whatever you want, we're going to strictly construe, and we're going to keep you to what you say. We're going to keep you to the words you use in the taking order. And we're going to keep you to the words of and we're going to keep you to what you do. Conrail practically located in a certain place, and that freed up the balance of my client's property to do with it as my client had a right to do. Now the Commonwealth is saying well, don't apply that rule that you would apply in a voluntary transaction to the government. It's just the opposite. We're trying to restrain the government from unfairly taking property rights and not paying for them. And that's all the T wanted to do in this case. And we asked this court that the lower court should be overturned and my client be given an opportunity to present be paid for the fair value of what was taken from them. Thank you.
Okay, thank you. Attorney Kincher.
Thank you. May it please the court, my name is Kendra Kincherf, Assistant Attorney General representing the Massachusetts Department of Transportation. This case is all about the 1991 order of taking. And the Commonwealth very clearly in that order of taking took a 26,240 square foot parcel, which is now the 12,510 square feet at issue in this case, owned by Smiley. The order of taking, as we've already discussed, my brother discussed, was for the purpose of constructing the Hall Road as well as relocating railroad rights of way and facilities, not just the rights of way, and that it shall be used for railroad purposes only. The owner of the property at the time was compensated for the entirety of that easement taken. And 31 years later...
Yeah, but so what does it mean when the air rights come back to him the Smiley's 12 years later? Because if you can keep changing your mind and putting buildings wherever you want forever, they can't exercise any air rights, right? So there's got to be some limitation there, isn't there?
There is. The first problem, however, is that Smiley reads out significant portions of the air right provision.
Okay, well,
of the air right provision.
Go ahead, because I'd really like to understand how the air rights provision interacts with the rest of it.
Yes, absolutely. The air rights provision starts out by stating said railroad easements, again defining the easements as for railroads, is limited in vertical dimension. That has nothing to do with the horizontal dimensions which are defined elsewhere. This is a limited vertical dimension of the 20 feet 6 inches. That height of the easement that is being taken by the Commonwealth is defined, it's a starting point. The railroad lays down its tracks, and at that time, you now understand how to measure that 20 feet 6 inches. But it's across the entirety of the easement parcel.
But so what does that leave you? If you can put things, because you need to have something to build on, right? You don't have it. They can't they can't defy the laws of gravity and build a building 20 feet in the air that doesn't have any foundations, right?
Correct.
So
And then
what-
it goes on to state, and this part is also omitted, is that the use, Smiley's use of the land is significantly limited, as you just acknowledged. And that is, Smiley must first obtain the consent of the easement holder. That is the Commonwealth, MassDOT. It is also CSX, who continues to hold easement rights in this parcel as well. And then, even with that permission, that can only be used as reasonably may be required for access to and to support the uses of the air rights. So Smiley has to come to MassDOT with a plan saying, I'm going to develop my air rights. I need to use this portion of the land in order to be able to access that development. Is that permissible, MassDOT? MassDOT says yes. They place the stairwell in a certain location in order to access its
We have-
development over the 20 feet 6 inches.
I take it there's some, but again, so does that mean you can, as long as you're using this for railway purposes, you can use the entire parcel and prevent Smiley from building anywhere on that parcel, you know, because you may need it sometime? What is the 12 years, what's purpose is the 12-year expiration period?
The 12 years was only related to MassDOT, the Commonwealth's ability to use Smiley's air rights.
Right.
The
but so
12 years expires MassDOT's ability to use over that 20 feet 6 inches, but below that 20 feet 6 inches, the Commonwealth has the ability to use the entire easement.
He argues that that was meant for you to, you know, basically put up or shut up, that you had to build or move your rail, you had to put your lines in, you had to put your facilities in, so that then the Smileys could exercise their air rights. That's why there's a 12-year provision, but you can't just prevent him forever from using his air rights, because after 12 years, he has air rights. He argues, and I don't know if he's right, that it covers the whole property where you haven't built anything within 12 years. You're arguing you got nothing that we don't give you because we can always put a building there or put a track there as long as it's for railway purpose, right? That's your position.
That's precisely what the order of taking states.
So what did he get in terms of air rights?
He has the ability to develop the air rights and that which is necessary to access those air rights. And again,
But you may need a new test track somewhere else, and you don't have to give it to him, right? You basically say, we totally control this property, and we don't have to give you anything.
the easement doesn't cover the entire property that Smiley owns. The 12,510 square foot parcel that is encumbered by the easement is a portion of the property.
Right, but as
And-
far as that burdened land, your position is that MassDOT gets to move its rails, build its buildings wherever it wants to on that burdened land.
That's exactly what the order of taking permits
And
it
so
to do.
given that position, how do the air rights provisions make sense?
The air rights provision makes sense is because Smiley can come to them. They have an actual plan of the development rights to the extent that they need to place a structure on the property. They ask for permission to do so. And that's to ensure that there is not going to be an unsafe interaction between an operating railroad and a residential
Right on the property,
use.
though. When you say on the property, you mean on the 12,000 plus?
Correct, but they have full ability to use the remainder of their property that is not encumbered. There are numerous developments in South Boston where you have cantilever developments.
Okay, so-
Counsel,
So
could I-
what's your, go ahead.
I'm sorry, could I just, because I'm still stuck with, I don't know if you answered Justice Kafker's point. If you're talking about the burdened land, you're giving us a conceptual, hey, the Smileys can come with a plan, and say, here's how we propose to develop this. When we know in practical matters, in this world, they're never going to say, okay, right? They're always going to be, because way back when in 1991, you didn't contemplate a test track. So that's now what you're relying on to say, we didn't think about it, but it reserves to us this railroad general kind of activity that we can always then default to. So why would the T come back and say, we know we've got this burdened land, we know you got these air rights, but we're going to somehow hamstring ourselves in the future by saying, okay, go forward with your plan. That's never going to happen, right?
It has happened. This is well beyond the record, Your Honor.
I don't even want to go beyond the record. I want to go to the burdened land that you gave to us, that the Smileys could come to you or come and say, please, here's our plan to develop these air rights, and somehow, in some way in this world, they would say, that makes sense, go ahead.
Yes, there are the options and the ability to have this coexist. They need to come with a plan. They have never, again, in those 30 years, come with a plan and asked for such permission. And as a result, MassDOT can use the easement rights that the order of taking granted it. And the order of taking is very clear. It has, in numerous provisions throughout the document itself, identifies with very specific dimensions, meets and bounds descriptions, that the easement is the entire easement parcel at dispute here.
Sure.
It's located.
So you wouldn't say that in practical measure you've taken the fee?
No, because they still have, as they noted, valuable air rights. But as the attorney Jeff Mullen, who was the person who negotiated this entire process, the owner at the time was compensated, understanding that their property rights were significantly diminished. So while they no longer have the ability to use the land itself, they still are able to use the air rights. That's the basis of the...
And what's the value of that if you have a complete veto over them using the air rights?
I'm sorry, I did not hear you.
What's the value of those air rights if over the entire 12,000 plus square feet, you could veto anything they wanted to do that required use of the air rights?
It states in the order of taking that the Smiley has the ability to use the land as reasonably required to access the air rights. That was what was used as part of the determination of what was being taken from Smiley.
For the 12, so the 12,000, because I have the same question just Slowy has. The 12,000, forget about the remaining. So it's 26,000, 12,000. What is the difference between you having basically fee simple rights on the 12,000 versus what you say you have?
The difference is the air rights, and as
the air rights are totally subject to your control, right? What is the limitation on your veto power in Justice Lowy's terms?
Reasonableness. There is always a reasonableness standard when interpreting that. You have to. You can't just unilaterally veto it just because you don't.
So you can't say as follows: because we have the right to create reasonable, we have the right to move facilities and do anything for railroad. You say you have the right on that 12,000 to do anything you want for reasonable railway purposes, right? Right?
Yes.
So is there any time where if you want to, are you saying it's reasonable for you to reserve those 12,000 feet forever for potential railway purposes, and therefore they can't build on the air rights on that 12,000 feet? Or is that unreasonable for you to reach that conclusion?
Well, I disagree with the connection there. It is,
But
we
there is.
have an easement on 12,510 square
And I'm
feet.
trying to understand how that's not basically fee simple, because you have the right to use that property for railroad purposes, right?
Correct,
And you say that right goes on forever,
it does.
so, totally apart from the air rights.
Correct.
The air right has not in any way limited it. It's not as he argues. He argues you had to pick what you wanted within 12 years. You go, no, that's not it. We have reserved the right for whatever we want until doomsday to use this for railway purposes.
Correct.
And you're saying, no, there's a restriction for reasonable. But as far as I can tell, the only restriction is for railway purposes.
The restriction on our use is railroad purposes. Smiley can access its air rights, and if that access is not going to interfere, as as your court's hundreds of years of case law indicates, if my easement rights, or if Smiley's use of the air rights are not going to interfere with my easement rights, then that can be permitted.
But so give me an example of something, how they could use their air rights, consistent with your reservation of a right to put anything you want for railway purposes there. Give me one, just one.
Yes, so as I stated, this is an 18,000 square foot parcel. They can create the base of the development on the portion that is not encumbered, cantilever it over the 12,000 square feet, and to the extent that they need to access that area that is being cantilevered over the 12,000 square feet for maintenance, or to, for example, for maintenance of the underside of the cantilevered portion of it, then MassDOT would be able to allow access in order to do that.
It wouldn't be required to, it could, in its discretion, if it felt like.
It wasn't going to interfere with the railroad uses, correct?
Right, but those railroad uses include buildings for you, right? You could build a manufacturing plant to build railway cars, right? You could have a storage facility for railway cars that's, right?
Yes, a storage facility that is used for the railroad itself is permitted under the easement.
But even more practically, I guess I'm going back to the question I asked you before. With them never ever being able to truly look into a crystal ball and see what the potential railroad uses might be in the future, they're never going to say yes to that. They're never going to say yes to that.
I think that it's contemplated that, for example, the example that I have given you is certainly what is contemplated at the ability now. And I would like to remind you that this was a significantly larger parcel. Their ability to use their parcel was mostly impacted by the city of Boston's taking for the convention center,
Can I
and
ask
not
one
ours.
more question, Chief? If we're done with air rights. So this was not a taking in fee simple, right? It was a taking as necessary to relocate portions of the railroad rights-of-way of Conrail at the time, and the relocation of Conrail facilities. How do you square that with your position now that this is essentially a fee simple in the burden land for limited purposes, for railway-only purposes, but anywhere we want on this burden land? But when the actual taking is necessary to relocate portions of the railroad right-of-way.
This was because Conrail, a railroad company, was being displaced.
No, so I understand the historic context. I'm trying to go back to the actual taking, which says it's a taking that is necessary to relocate portions of the railroad rights.
Correct, but it's rights-of-way and facilities, and then to use it for railroad
To
purposes
relocate
only.
those things.
But if it was to just pick things up and put them down, Conrail wouldn't be able to use its railroad tracks. A railroad track requires much more land than the track itself, and that's even under federal law. There are
It
clearance
doesn't talk
for...
about, I'm not limiting them to the tracks. I'm trying to get back to the language of the taking, which is to relocate portions of the railroad rights of way, not the tracks. I mean, the rights of way would be bigger than just the tracks. So that argument is sort of a red herring. I'm trying to focus you on the language of the taking, which wasn't, we're taking in fee simple, the
Correct.
burden land. It is taking for the purposes of relocating these rights of way and facilities.
Correct, for an easement, a railroad easement
For
on
those,
the
for the
property.
relocation, not the relocate here year 1 and year 2 and year 3, and what your opposing counsel is saying, yeah, you can do that, but you got 12 years because otherwise the air rights don't make sense.
But that's not what the order of taking states. And it talks, when we're talking about the geographic scope, and I think that's what you're getting to here, is that the dimensions of the parcel, the easement being taken, easement in the order of taking is identified as parcel 60ERR1. And that is defined in several sections of the order of taking. At Record Appendix 46, it states that the easement is shown on the plan hereafter referred to. At 48,
Right, yeah, no, I understand it defines the burden land, but it defines the easement for the purposes of relocation, and I think it would be great if you could answer that question. How do we square, for the purposes of the relocation of the facilities and the rights of way of Conrail, with your position that effectively this is a fee simple in the burden land, limited only by section, sub I?
In order for Conrail to have been able to use that relocated operations, it was being given the entire easement parcel. It's an easement, it's not a fee simple, but it's picking up railroad operations so that they can be placed in a different location,
Right,
so
but I
that the
think
haul road can be
Justice
constructed.
Wendland's saying, this is a new railway. This isn't part of the relocation. This is a brand-new railway use that wasn't projected at the time. It's something totally new. It's not relocating Conrail. It's a brand-new railway activity that has nothing to do with the relocation of Conrail. It's basically the DOT's vision for the future.
And the order of taking contemplated that there would be different uses in the future. So for example,
Does it say that? That would be very useful. If there's something in the taking that points us to that.
for example, on Record Appendix, I think it's 47 to 48, it talks about successors to Conrail. And it talks about a successor can use the easement parcels not only for the freight use that Conrail was using it for, but it could be for passenger use. And passenger use is a different type of railroad use than what was contemplated by Conrail, and could potentially need the easement parcel for in different ways. This court's case law on railroad easements for hundreds of years have always stated that the initial use of an easement is not set in stone, and that the easement holder can use it for different purposes so long as it's within the layout of the railroad itself. Here, MassDOT's railroad purpose of Red Line Test Track project is squarely within the easement parcel itself that is defined by the meets and bounds on that layout plan. And it is undisputed by the parties that it is a railroad use.
Okay. So you're just saying that this is a great way for the Department of Transportation to get what they need in a cheaper way. They don't have to do it by way of purchasing the land. They can just take it and say it's an easement, but then use whatever part of that area they want to.
Railroad easements are just that, and they have been for hundreds of years.
So
And
once
they
you
are
put down the tracks, it doesn't matter, you can pick them up and move them to other parts of the place so that whoever owns it, how are they ever gonna use their land?
That has been the law of this state as set by this court for hundreds of years, yes.
But you're talking, when you talk about Leroy and you talk about, that's really a use in kind case. It's not really a case about the initial purpose of the taking.
I think all of the railroad cases and all of the eminent domain case law is very clear that so long as you are within the easement area that was taken, and so long as you are within the easement purposes here,
Right,
that's
within the
the
purposes.
railroad uses, for railroad rights-of-way and facilities, here, the Red Line Test Track project is a right-of-way and related facilities.
But it has nothing to do with the relocation of Conrail's
And again,
rights-of-way and facilities,
it was
right?
never contemplated that it was just, I'm going to pick things up and I'm going to put them down. It was, Conrail was going to continue its operations. Those operations, as cases discuss, are not set in stone. And even though it's just a railroad easement, the owner is compensated for the extensive taking. It's understood that it is its uses are significantly curtailed by the order of taking, and it was compensated for that properly in 1991.
Do you have any cases that'll show what that means, the significant taking? I get it. So the owner, the original owner, understands that Conrail's going to move their things here, and here they are. And anybody else can do the same for railroad purposes. Do you have a case that says that things can be put anywhere on that property, or facts where things have been moved to different places within that property? And
Yes,
that was
Your-
the proper use of the easement?
Yes, Your Honor. And that was actually in a couple of cases. First,
I'm way over time, and I think people are tired, but if you can just give me the cases.
sure, in Leroy itself, it indicates that that was a case in which there was a narrow gauge railway. It extended to a double-track electric trolley line, and then it was further extended so that it could be used for motor
Isn't
buses.
that a public use in kind case as opposed to the limits of an easement going back to its initial purpose?
No, because it did indicate in there that it is related to the original purpose, and the court stated that was true even though the new modes traversed over any suitable part of the location. And it's not that you fix a path based upon the original setting down of that single gauge railway. The court determined that the use was still consistent with the original taking. And that is exactly what we have here. We have a railroad use that is within the original easement area taken. And so we are not going beyond the scope of the original easement itself. It is not only consistent with a purpose, it is consistent in kind, and it is consistent with the rights that the original property owner were compensated for.
Okay, thank you very much.
And I would just refer the court to the other cases that I cited in my brief, and ask the court to affirm the decision below in its entirety. Thank you so much for your time.